Hi, this is Devin at Westchester Residential Opportunities, and this video is part of our series on the basics of the fair housing laws. The normal caveats and disclaimers apply. This presentation is being prepared in March of 2021 and may not be accurate on any other date. We are not providing legal advice in the video. If you need legal advice, please engage a lawyer. Today we're talking about fair housing protections for the LGBT+ community. Due to a recent Supreme Court ruling, there is a new wave of LGBT+ housing rights on the horizon. So let's get into it. The characteristics or group identities that are protected under the law differ by jurisdiction. We usually refer to them as protected classes, but there are lots of other terms you may hear, like protected characteristics, protected bases, or protected groups, and they all genuinely mean the same thing. The federal law protects just 7 protected classes. Whether or not these classes include queer individuals is changing, and we'll discuss more today the current state of that debate. New York State adds a number of additional protections, notably including sexual orientation, gender identity and expression, and source of income. Within New York, many counties have additional or different provisions. Here you can see Westchester's additional protected classes. Lots of details and nuances to get into if you want, beyond sexual orientation and gender identity. Okay, so those are the protected classes. What does the law say you can and can't do about them? We refer to those as the prohibited acts. Housing providers and lenders, such as landlords or mortgage brokers, are barred from treating clients in such a way. They are fairly intuitive. For example, you can't refuse to rent to someone on the basis of their protected class, like being black or being gay or having children. Likewise, a landlord can't lie and tell someone in a protected group that an apartment isn't available when he's telling someone else that it's ready to rent. Or setting different terms and conditions, like saying, you can have children in the apartment, but I'm going to charge you more, or only allow you to live on the first floor. Now that we've covered the basics of fair housing, we will be examining the protections that exist for the queer community at each level, national, state, and county. On a national level, the LGBT+ community is protected from discrimination in HUD-assisted or insured programs. This is due to the Equal Access Rule, which was issued by HUD in 2012 and established protections for sexual orientation, gender identity, and marital status. Under the Trump administration in 2020, this rule was adjusted by HUD. HUD confirmed that shelters, which are single-sex or sex-segregated, are able to establish their own policies on gender identity. This creates room for policy-wide gender identity discrimination. Fortunately, the federal civil rights of LGBT+ individuals have recently been expanded due to recent court decisions and executive orders, as I will later elaborate on. At the state level, there are 2 laws that ensure fair housing rights for the LGBT+ community. Collectively, these laws safeguard the queer community from discrimination in ways federal policy does not. First, the Sexual Orientation Non-Discrimination Act has been prohibiting discrimination based on sexual orientation since 2003. Prohibitive acts include all forms of discrimination established by the New York Human Rights Law, including housing discrimination. The Gender Expression Non-Discrimination Act of 2019 works similarly, prohibiting discrimination based on gender identity or expression under the New York Human Rights Law. Moving on to the county. The Westchester County Human Rights Law protects individuals from discrimination based on their gender identity, sexual orientation, and gender expression. The law applies to housing, credit, and employment, as well as places of public accommodation. Similar to New York State policy, this extends beyond the protections that currently exist on the federal level. Now let's take a look at why LGBT+ fair housing protections are such a hot topic right now. Greatly expanded rights on the federal level. In 2020, in the case Bostock v. Clayton County, the Supreme Court established that in regards to employment discrimination, sex included sexual and gender orientation. The 6-3 decision interpreted the 1964 Civil Rights Act definition of sex to include gay, lesbian, and transgender individuals. Writing the decision for the majority of the court, Justice Gorsuch stated, "It is impossible to discriminate against a person for being homosexual or transgender without discriminating based on sex." This opinion was reinforced by President Joe Biden. Today, by affirming that sexual orientation and gender identity discrimination are prohibited under Title VII of the Civil Rights Act, the Supreme Court has confirmed the simple but profoundly American idea that every human being should be treated with respect and dignity. Now, as to how this ruling could be relevant to fair housing. On a national level, the LGBT plus community now has established federal protections under HUD's interpretation of sex under the Fair Housing Act. At the direction of President Biden, HUD, in February 2021, announced that it was interpreting sex discrimination to include sexual orientation and gender identity, in alignment with the Supreme Court's Bostock v. Clayton County ruling. President Biden's directive and HUD's announcement that it would follow the Bostock ruling in the fair housing context makes a lot of sense due to the similarities between the language of the laws and regulations governing employment rights and housing rights. This is in addition to the pre-existing 2012 Equal Access Rule, which prevented HUD programs from discriminating on the basis of sexual orientation and gender identity. These changes are important. Under the Biden administration, sexual orientation and gender identity will receive the same protections under the civil rights laws as are afforded to race, religion, disability, or any other protected class. If the Supreme Court interprets sex under the Fair Housing Act to afford the LGBT plus community protections, like in Bostock, that will further close the gap that exists between queer people and housing, making it significantly harder for any subsequent administration to back away from protecting the LGBT plus community. For now, there's no ambiguity as to where the federal government stands. None of the prohibited acts established in the Fair Housing Act may be practiced against the LGBT plus community. This includes refusing to sell and rent to queer families. The LGBT plus community has the right to an equal experience at every step of the housing process across the nation, regardless of what local protections a state or county affords. In addition, queer individuals and families who do think they've experienced discrimination can bring discrimination cases at the federal level, either directly to HUD or in federal court. Not only does this increase the opportunity for justice, but it decreases the likelihood that housing providers will take the risk of discriminating. Thank you for watching our video. If you're aware of housing discrimination, please reach out to us to report it. Easiest way to reach us is by email. We have a staff directory on our website. You can see the address on the screen. Email anyone in the Fair Housing Department. And while you're visiting the website, please take a moment to support WRO by clicking the donate button. Housing is always essential, and we're here to help. Like, subscribe, and share this video, and please follow us on social media.